I'm pleased to introduce our second lecturer today, Professor Constantino Chagas, Lessa, who has completed her PhD in Maritime Law at the University of London. She has lectured commercial and maritime law for many years at the University of Westminster and finally at Erasmus University of Rotterdam. Recently, Julia moved back to her home country where she set up her own consultancy law firm and currently working in setting up American law courts. Julia is involved in numerous academic activities, being the board member of the German American Maritime Institute, one of the executive editors of the International Transport Law Review. She regularly speaks in academic and industry conferences, having published articles in several renowned academic law journals. Today, her presentation will be about cross-border insolvency in the shipping industry and the problems of dependencies. Professor Chagas, Lessa, the floor is yours.
Morning. Let me know if you can hear me or if you cannot hear me better. I'll try to speak as loud as I possibly can. I think I must thank Igor for the opportunity once again of speaking at this conference. I was thinking yesterday, every time that Igor invites me to this conference, something happens. On the first year, I had a broken rib. So I was struggling, a lot of pain most of the time. And this year, last year, I got COVID, just the same time at the conference, I got COVID. And this year I'm in Brazil, struggling with the time difference. Like right now, it's 5 o'clock in the morning here. So as you can see, it's still dark outside. And I believe that I need to also make a quick apology here because a few of you might have seen this presentation. I have been presenting this topic for a while now, and I decided to make it more introductory as possible to not be very specific in one of the issues, be more general, broad, bringing actually the problem of cross-border insolvency in the industry, rather than nitpicking one and scrutinizing this one. So I'm going to, in order to do so, I always take the Hanjin collapse as like a platform for scrutiny. It's because of the size of the collapse, considering how big the company actually was. And the number of countries that got involved in the insolvency proceedings, because again, it was the 7th largest container line in the world, and a lot of countries got involved either because they had seized vessels, there were creditors all over the world. I'll get into more details in a while. And then I'm going to be talking about some peculiarities of the shipping industry, that is the right in Bremen privilege claims. My God, you can see that I have been speaking Portuguese a lot, my English, I'm struggling here. Arrest versus cross-border insolvency law, I'll talk a bit about this and how it can bring perfection. I'll cover likely a few of my ideas. So currently, again, we have a crisis. We always, in the shipping industry, I always make a joke that it's like World Cup, the price comes and goes every 4 years, you know that the World Cup's there. Every 4 years, you know that a little price will be there. We are currently facing one, but it's more about actually logistics. It's more about the lack of container. It's more about ports not being able to keep speed. I recently, very recently, last month, I moved from the Netherlands to Brazil. It was very difficult to find a container. So it's again facing actually it has been said there are not enough container vessels at the moment. So let's see what will happen, because like last time that there was this problem, there was a huge demand for container vessels. There was a lot of ship owners buying container vessels, and then there we had the 2008 like crisis. There were a lot of ship owners went bankrupt again. So let's hope this will not be a result of our current crisis. So breaking up the Hanjin structure, it had 132, the company structure, it had 132 containers in both ships, as well as half its fleet charter. They had like vessels chartered. They had 60 regular routes, which is quite a lot. And and again, Eva, is okay? Can you hear me? Fine. I try use like my earpods. So the problem with the Hanjin when it collapses is a South Korean company. It was a South Korean company. So once it collapsed and bankrupts, like the restructure plan was not accepting South Korea, and it was going to be declared bankrupt. What happened with the vessels that they were literally being seized everywhere, but they also received orders to not enter ports. Why is that? Like to remain in international waters. Because South Korea wanted actually to go to these countries and say the same notification to these countries that the bankruptcy proceedings had been opened in South Korea. So again, so they had stayed of any sort of like arrest or like, so the insolvency proceedings in South Korea would have preference over any other sort of debt that the company might have in that particular country. So a lot of Hanjin's vessels were kept in international waters, were actually kept in international waters for quite a while in order to prevent arrests. I have an alarm clock ringing at crazy in my house, and I don't know what it is, so bear with me. That's why I'm a bit lost. So there was a lot of containers, like Constantino also left containers, and not only vessels. Like a lot of containers are left in port. Also, these are part of the insolvency. These are also like company assets. This is also like when Hanjin was going through the financial crisis, like seafarers were actually they were stranded on board of these vessels, like without any support, without food, and they were like saving the vessels. And seafarers are like actually they do have privileged claims over the vessel itself. So it's a huge problem. So the timeline of the Hanjin bankruptcy was this. 31st of August 2016, the procedures were filed in South Korea. On 1st of September, we had the rehabilitation order. In September 2016, South Korea's financial regulator sought stay order in 43 countries to protect its vessels from being seized. Meaning that, again, things so like the insolvency proceedings would have preference, meaning that the creditors and the South Korea bankruptcy procedures would have a preference, and the creditors listed therein would have a preference over the, this is in a nutshell, over the company assets. On 19th of September, order to end the vessel's charters agreement. Because one thing that I forgot to mention is that like when Hanjin went bankrupt, but I think you probably noticed from what I have said previously, there were still actually were still actually feeling charter agreements. So they were still in like they were still in group. A lot of the vessels were still in group. A lot of the vessels were actually still finishing charter agreements. And then finally, on the 2nd of February, there was 2017, there was the bankruptcy declaration. So technically, that is like very known in terms of ship arrest, in terms of uniformity, and like he also writes a bit about cross-border insolvency. He says that in terms of ship arrest, what we have that the benefits of legal uniformity in the area of the arrest of ships and the countervailing disadvantage of legal disharmony in this field are impossible to exaggerate from the standpoint of all partners in the maritime community, ship owner, underwriters, claimants, judges, lawyers, and government. What I mean to say here is that, like, actually, countries nowadays we do have, like, let's say, a soft law regarding this, which, in terms of arrest. But necessarily it is a lack of uniformity still. And the problem with a shipping company when it goes bankrupt is that, like, literally, their assets are essentially the vessels itself or the containers. But so the vessels will get arrested eventually. But also over those vessels, we also have like rights and rem, we also have privilege claims. It is also the third problem that Constantino faced. A lot of their vessels, actually, a lot of the vessels that it was using to fulfill charter parties were actually time chartered. So the company itself did not own the vessel. So, but it still could be seized in terms of like for creditors or arrested in countries all over the world. So there was a lot of problem with Constantino and like the whole bankruptcy scheme due to its size, amazing size, due to the fact that no one expected the company to go bankrupt, and due to the fact that, like, literally the company was still fully active at the time of the bankruptcy. So there was a lot of things that had to actually be put in place in terms of logistics, you might say, to actually protect the rights of creditors. I would say favorite creditors, but in the sense that, like, to protect, in this case, was to protect the rights of the creditors of the bankrupts over the rights of, like, administrative creditors, let's put it this way. So South Korea was really actually try its best to actually protect the rights of the creditors in the bankruptcy proceedings over any other right that could arise out of administrative claims. Because, of course, when a company opens bankruptcy proceedings, the first thing that happens is that, like, everyone who has some sort of claim against the company is going to try to go after the vessel or go after, like, its right in the country where the right could arise, especially if we talk about privilege claims. Because, like, we do know in bankruptcy, it's very difficult. There is a completely different order of creditors than administrative creditors, than maritime law creditors and civil law creditors, and it is completely different and distant. So we have, like, this conundrum. That's how I call it. That is the administrative proceedings versus solvency proceedings. Because, like, administrative creditors who want their rights to be actually protected beforehand, and solvency proceeding creditors who also want their rights to be protected. So, so rights in Bremen, privilege claims and mortgage, they usually give a right. Privilege claims and mortgage, they give a right over the vessel itself. So there are a lot of things that give rights to this right. Unpaid wages, salvage, salvage awards, port to mortgage, A maritime lien by itself is defined as a claim or privilege upon a thing to be carried into effect by legal process. This claim or privilege travels with the thing to whosoever's possession it may come. It is inchoate from the moment the claim or privilege attached and when carried into effect by legal process. By proceeding in rem relates to back to the period when it first attached. This was the definition given by English law. If I seem distracted, because I am, there is alarm clock ringing here that I don't know where it is, and this alarm is. Like this is my conundrum of being at my parents' house, that I don't know where things are. So I do apologize. I'll try. So maritime lien is a privilege over the vessel itself, and this is a common law approach. So English law, they have the view that a maritime lien is always going to give a rise in rem, going to give a rise in rem, which is not necessarily true for civil law countries. Civil law countries, they feel like there is a right in rise that is really connected to the thing itself. But in common law, like UK, always views the common law approach that the lien itself gives a rise to, like, gives rise to a right in rem, to a right over the vessel itself. So a few characteristics of an action in rem are: once a claim form in rem has been issued, a change in ownership in the vessel being effective. Can I excuse myself for 1 second, please? Can you just give me 1 second? I'm sorry. I'm really sorry, but the noise was driving me crazy. So characters of an action rem. So once a claim form in rem has been issued, a change in ownership in the vessel being effective to prevent action proceed against it. And then effect known colloquially as statutory lien. In the absence of statutory permission, an action rem lies only against the vessel connection with which the claim arises. I'm not going to read anything, so read everything. So again, a cause of action of an action rem does not merge the judgment persona. You don't need to go after the ship owner, right? So you can arrest the vessel, and like you have the right over the vessel itself. So it's an interesting, and it's different from insolvency proceedings, because definitely insolvency proceedings we have like the right to rest, like in the sense that you go after the company itself, you go after the company that went corrupt. But then you see the conundrum here, right? And then you have to think, brilliant, like, so we have a model law for cross-border insolvency that will actually you make it uniform, the law regarding the cross-border insolvency law. So the model law. And then you think like, oh, well, there is no problem. There is a problem, because it's decided, like when I was talking about the Hanjin law, South Korea had to issue like 48 states. So there were a lot of countries involved. Like there was a lot of countries that they have to issue. So it's a lot of work actually to issue these orders, to get to the court and to actually stay proceedings because the bankruptcy was open in South Korea. So again, this is judicial, it takes a while, it takes time. And until this happens, until the court of these countries do not receive like these stays, they can actually deal with it as they please. In the sense they can actually arrest the vessels due to admiralty claims. They can arrest the vessels for writing rent for privilege claims. They can do whatever they want as long as the vessel is in, for instance, in Amsterdam, and there is a claim that somebody like actually files a suit to arrest the vessel. That is, again, arresting the vessel is ex parte, so only the one part there. So you go and arrest the vessel is arrested, and you have a claim, and the state of like South Korea has still not arrived there. So before there was the arrest of the vessel for that admiralty claim, so only after receiving the stay of this bankruptcy proceedings. So we begs the question, like, whose rights prevails? Like the ones from the admiralty creditors, or the ones from the insolvency, like, or the ones from the insolvency creditors, of the insolvency creditors? So this is the problematic in terms of cross-border insolvency in the shipping business. But then there is an exception in terms of like rights in the model law. The model law is actually quite criticized because it's like most laws are made to make something uniform. The language is broad because it gives space, liberty in terms for the parties to be a bit discretionary, if you may say so. So, Model Law Article 22 is that the scope and the modification or termination of the stay and suspension referred to in paragraph 1 of this article are subject to refer to any provision of law of the United States relating to insolvency that apply to exemptions, limitations, modifications, or termination respect of the stay and suspension referred to in paragraph 1 of it. Paragraph 1 says talks about the commencement or continuation of individual actions or individual proceedings concerning the debtor's assets, rights, obligations, or liabilities of the state. Execution against the debtor's assets, state, and the right to transfer into a birthright. But then you have to consider the law of the country. So you are going to see that the UK of the country itself. So you will see that the UK has an exception. Australia has an exception as well. So according to the UK Court of Arbitration Regulations 2006, the stay and suspension refer to paragraph 1 of this article the same in scope and effect as is if the debtor in the case of an individual had been adjudged bankrupt under the Insolvency Act 1986 or had his estate sequestrated in the Bankruptcy in Scotland Act, or in the case of a debtor other than an individual had been made the subject of a wind-up order under the Insolvency Act 1986, and subject to the same powers of the court and the same prohibition, limitations, exceptions, and conditions as would apply under the law of Great Britain. In such a case, the provisions of paragraph 1 of this article shall be interpreted accordingly. So you are going to see that there is, so without prejudice to paragraph 2 of this article, the stay and suspension referred to paragraph 1 of this article in particular does not affect any right. to take any steps to enforce security over the debtor's property, to take any step to repossess goods in the debtor's possession under hire purchase agreement, exercisable under by virtue of connection with the provisions of Article 1.4, or of a creditor to set off its claim against a claim of the debtor, being a right which would have been exercisable if the debtor, in the case of individual, had been adjudged bankrupt under the Insolvency Act, or had his estate sequestrated under Bankruptcy Act 1985, or in the case of a debtor other than had been made the subject of a wind-up order under the Insolvency Act 1986. So in the case of the UK, you see that they value actually the privilege claim and the admitted claim that was open before actually the state. So Australia has an exception for admitted proceedings that are happening when that are taking place before the state order has actually arrived. The US has it as well. So it is said that Article 20, that of the European Insolvency Regulation, also says an exception for lawsuits that are pending, so they actually get preference over the insolvency procedures. And Article 8 gives an exception for rights in rem, but it's actually rights in rem itself, but not privileged claims. Because then we go again, the EU common law sees privileged claims as right in rem, but Berengeri, for instance, has written about the subject and said that he doesn't feel like privileged claims, maritime law and civil law countries should be seen as a right in rem, but a right in res. So the exception of Article 8 would not apply to privileged claims. So essentially, what we have in cross-border insolvency law is the times of death. Because what is the times of death? What are we talking here? Why did Hanjin stop its vessels to actually reach the ports? They prevented like the vessels from reaching the ports because it wanted a stay of proceedings of issued by South Korea to arrive at that particular port before the vessel itself. So the vessel would not be arrested at that port and would be subject to the insolvency proceedings back in South Korea. So times of the essence. So it was a dangerous and was actually shocking. Not very shocking, but it was intelligent and like word is my mind, but it was a cheekless game that like South Korea played or Hungary played in terms of like actually asking the vessels to remain in international waters. They knew that the state of proceedings had been reached in the ports of that particular state. It was a dangerous game, but still it was worth it. So why do the order of proceedings matter? Because this is the most susceptible thing that the commencement, we have countries that we have that the commencement of the merit proceedings, opening of the insolvency proceedings, and recognitions of insolvency proceedings, right? So we have first the commencement of merit proceedings, opening insolvency proceedings, recognition of insolvency proceedings. In this particular case, the admitted proceedings would prevail over the insolvency proceedings because it was open before the insolvency proceedings and the recognition of the insolvency proceedings. The set of situations that have the opening of the insolvency proceedings, the commencement of admitted proceedings, recognition of insolvency proceedings, and in this particular case, also the admitted proceedings will prevail over the insolvency proceedings. Because the recognition only came after the admitted proceedings were already open. This again justifies the game that like Hanjin play in terms of like keeping its vessels in international waters. And finally, you have the opening of the insolvency proceedings, recognitions of insolvency proceedings, and then commencement of admitted claims. In this particular case, the only thing is that it's accepted that like the admitted claims do not actually prevail over the insolvency claim. So this is like what happened in Australia, and it's interesting to see because I kind of make the timeline of the case, and it actually recognizes, but there is like what happens a lot in terms of insolvency. There is a lot of bureaucracy involved, and there is, I think, the person administrating the insolvency proceedings in South Korea actually not send the relief and the appropriate relief to the interim relief to the Australia court. So, like, recognize at first the proceedings, but because of this administrative error or delay, said like, okay, we have to spend these. We're not recognizing these at the moment. So there was that gap on time when it was not recognized, and therefore in that particular time gap, administrative proceedings could go on, and then this was actually yes, Petra?
Yeah, I'm sorry, because of the schedule, you have only 3 more minutes. So please.
Oh, okay.
Thank you.
I will wrap it up in 1 minute. Sorry if I'm talking too much. So this time gap was actually quite dangerous because administrative proceedings could be open in this time gap, and then again was not recognized during this time gap, and therefore the administrative proceedings would prevail over the insolvency. These will cover really fast because one interesting thing about Hanjin is that Hanjin is a group of company, and group of company structure. It's really interesting. It's interesting in the sense that Hanjin was a company that was focused, like, in essence, was like this guy who focused on transport. So he owns every sort of transport method available in South Korea. And then there is this governance structure of Hanjin. But Hanjin is every single ship owning company. It's actually like their own. You're going to see Costco. They are Hanjin. In each country, there is a subsidiary. There is a daughter company. So in Brazil, there is a Hanjin company, and so there is the main one, the mother company in South Korea. But there's each country there are subsidiary ones. Like there are quite a few in Europe. And once Hanjin went bankrupt, there is a domino effect that all of them follow, but not necessarily in the same order. They all follow the bankruptcy proceedings, but they were smaller and they follow as well. The thing is that usually these daughter companies, they don't have a lot of assets, because one thing is that I always thought that like you can go after these companies' assets, but they actually do not have a lot of assets. Usually these companies, the way shipping companies work, they usually have one vessel under their name, and that's it. And I consider, for instance, putting the corporate veil or listing, if you may, and going to these companies before bankrupt, if you could not go actually. If you could not go to have like your admitted claim solved before the insolvency proceedings, because again, like when you talk about maritime claims, we do have a role, like in terms of like a role of creditors, like who have priority over the claims once you arrest a vessel. These actually orders not the same as the order in the insolvency proceedings, and this is the problem. This is the problematic. Like people who actually that sometimes features like are the first ones featuring like in the privilege claim list, the mere proceeding claims list, are not featuring, like are not the first ones featuring like insolvency claims. This is like where the conundrum exists and the problematic. But then it's very difficult to put the corporate develop a group of companies because there is economic entity doctrine. And there was a few I discussed here. There was a few possible solutions that come up, like in terms of better protecting the industry when the Hanjin case came was abrupt. Like so, there's vessel sharing agreement, insurance funds. It's really worth like seeing. I talked a bit like in my abstract, but because I had hopes for it, but my hopes were not actually met. That the recovery and resilience facility, like that was put in place by the European Union for like the pandemic, like at least one country, there are like billions, we're talking about billions, and at least one country would put a claim for in terms of ports and like in terms of digitalization. There's a lot of claims like that regarding digitalization and regarding because this fund is put in place to help countries actually emerge from the pandemic, but nothing was regarding this type of logistics. And we are facing a bottleneck right now in terms of transport, but I actually did not find that any country filed anything against this in regards to this, like in terms of ideas and projects. So I'll share my slides later so you guys can have a look in terms of idea of the insurance fund and the vessel share agreement. They also face a few bottlenecks that are like competition law and so on, but it's worth considering because again, cross-border insolvency, although uniform, there are a few gaps there. So thank you very much.